is absent.
Okay. Appearance. 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 Counsel, you have to unmute yourself.
With profound respect to my lord,
Yes.
my name is Udenyi Omaji.
Udenyo Omaji.
My lord?
Okay, Udenyo Omaji.
Well, my name is Udenyi Omaji.
Yes.
Yes, my lord. And I appear with
Yes.
James Odong Esquire and
James Odong.
Miracle Abong for the defendants, my lord.
Miracle Abong or Obong. Any appearance for the claimant?
Abong, my lord. Abong.
Okay. Okay, Abong. Any appearance for the claimant? Registrar, is the
I
claimant
can see the
aware of this?
claimant, but I think he's struggling
He's
to participate.
He muted himself.
I can see him here.
He's muted. I think the problem is his mic is mute. If you
Mr.
can
Honor, you have to unmute yourself to announce your
Good morning, my
appearance.
lord.
Yes, morning. Yes,
Yes, my lord.
appearance.
Yes, my lord. Samson Honor appears for the claimant, my lord.
Samson Honor. This matter is for judgment. The judgment is ready. And it goes like this. The claimant commenced this action by a general form of complaint dated 21st day of December 2023 and filed on the same date, accompanied by statement of fact, witness statement on oath, list of witnesses, list of documents and photocopies of documents to be relied on to be tendered at the trial. The statement of fact was amended by the order of this court, which was made on the 23rd day of July 2024 by the paragraph 20 of the amended statement of fact, which was filed on the 18th day of October 2024. The claimant claims against the defendant as follows. A, an order directing the defendant to pay the claimant his entitlement to the sum of 21,600,000 naira, being severance grant at 300% claimant's basic salary and at 300% basic salary, which is equivalent to 3,600,000 naira, and furniture allowance at 300% claimant basic salary, which is equivalent to 3.6 million naira, as provided for in the remuneration laws of Cross River State for political, public, and judicial office holders, number 12 of 2007. B, the sum of 10 million naira as general damages against the defendant for wrongful withholding claimant's entitlement. C, 30% interest on the judgment sum from the date of claimant's letter of demand till the amount is paid. Upon being served with the originating process commencing this suit, the defendant on the second day of February 2024, the defendant denied file a statement of defense denying the claim of the claimant and insisting that the claimant is entitled to his claim. The claimant testified in proof of his case as CW1. He adopted his witness statement, two witness statement on oath in evidence as his evidence in this case. He tendered 14 documents which were marked as Exhibit CWA to CWN. At the end of his cross-examination, he was discharged. The defendant also, in proof of her case, called Pastor who testified as DW1. DW1 adopted his witness statement on oath as his evidence in this case and tendered documents which was admitted in evidence and marked as exhibit DW1. After the cross-examination of DW1, DW1 was cross-examined and discharged at the end of his cross-examination. The claim of the claimant was engaged as chairman of Cross River State Board of Internal Revenue Service on basic yearly earning of 3.6 million naira at the expiration of the term of appointment in 2022. The claimant appointment was renewed and extended to September 2023. When the extended period expired, the claimant was relieved of his appointment. However, despite the letter of demand and the reminders to the defendant has failed and refused to pay the claimant his severance and furniture allowance in accordance with the Public Service Remuneration Employment Laws number 12 of Cross River State. That's why the claimant came to the court to seek for redress. The case of the defendant admitted claimant being employed as chairman of Internal Revenue Service, but denied all the claims of the claimant and went further to state that that the financial entitlement as contained in his letter of appointment and accepted by him are the only entitlement the claimant has with the defendant, and those entitlements are not under the Public Service Remuneration Law of Cross River State. The claimant letter of appointment is very clear and unambiguous as to the entitlement. The sum of 3.5 million per annum as contained in the letter of appointment was claimant's annual consolidated salary and not his annual basic salary as alleged by him. The salary of the claimant as captured in his letter of appointment, the claimant is not owed any entitlement as claimed at all. Counsel for the claimant filed a reply to the statement of defense where he stated that the words may use cannot be, the word may contained in the letter of appointment does not exempt the claimant from Public Service Remuneration Law of Cross River State 2007. In addition, the law setting up the board, which the claimant served as chairman, clearly states in Part 1 of Section 5 that the chairman and board members shall be paid remuneration applicable in the public service of the state. The submissions of the defendants formulated a single issue for determination whether the claimant has discharged the evidential burden required to entitle him to reliefs. I have captured the argument. I will skip reading the argument. Then the submissions of the claimant formulated 3 issues for determination. I have captured the 3 issues and argument canvassed therein. The defendant filed a reply on points of law to those 3 issues that were canvassed by the claimant. And now goes to the decision of the court. I have considered the processes filed by the parties and taken time to calmly read through the facts and evidence adduced by the parties. I have also taken time to scrutinize the several documents tendered and admitted in evidence. I have also considered the enlightening and weighty submissions of learned counsel for the parties, carefully noting the several decided cases relied upon by them. Coming to the determination of the claim of before the court, it has been established by a long line of decided cases and as argued by the learned Attorney General that the burden of proof in civil cases like the case at hand rests always on the person who asserts the positive. Therefore, the burden is on the claimant in the instant case to prove that he is entitled to relief sought. It is when the claimant has discharged this burden or onus of proof by adducing sufficient, cogent, credible, and admissible evidence establishing his claim that the burden will now shift to the defendant. This is because the burden in civil cases or matters is not static and may shift in the course of the proceeding in the case, depending on the state of the pleading at various stages. But in any event, the initial evidential burden to introduce evidence to prove a claim to illegal right or liability based on assertions of fact upon which right or liability is claimed is placed on the claimant, and until it is satisfactorily discharged by unbalance of probability or preponderance of evidence as required under section 131, 133, and 134 of the Evidence Act, it does not shift pursuant to section 133 of the Evidence Act. In this case, the claimant is the one that desired this court to enter judgment in his favor. That wants this court to enter judgment in his favor. In the circumstances, the onus is on him to prove his entitlement to the sum of 21 million naira, which he claimed as a bearance and furniture allowance, as provided for in the remuneration law of Cross River State. He is also to prove entitlement to 10 million naira as 10 million naira and 30% he is claiming on the judgment sum. Therefore, the claimant, both the initial evidential burden of proving facts he asserts and on which he bases his claim if judgment is to be entered in his favor. Cases in support of these submissions have been captured in the body of the judgment. What emerges from the above cited cases is that burden of proof in civil cases is of two types. The first is the term legal burden is the ability of a claimant asserting positively to establish and prove the entire to prove the entire or reasonable portion of his claim before the court for judgment to be given in his favor. This is always constantly on the claimant. The other type is the burden of proof which oscillate from one party to the other, depending on the state of the pleading. See the case of Ogule, Ankfa Agatu Cooperative Community Farming Society and Nigerian Agricultural Cooperative Bank. From the three reliefs being sought by the claimant, the first relief is the mere relief, while the two other reliefs are ancillary or appendages to the main relief. The success of relief 2 and 3 depend on the success of the first relief. In determining a case, a court is enjoined by law to restrict its consideration of the case to the reliefs contained in the claim. Put in different way, the court has no power to deviate or jettison the claim of the claimant as adumbrated by reliefs. In other words, the claim is determined by the reliefs being sought by the claimant before the court. See the case of Gabriel Atibi versus Kabel Metal Nigeria Limited. In line with the above decided authority, the court in determining the case of the claimant shall consider the relief sought by the claimant vis-a-vis the evidence adduced to see whether the claimant has proved entitlement to any of his reliefs. The first relief, which is the main relief, is for payment of the sum of 21 million naira 600,000 naira, being for entitlement of the claimant as severance benefit and furniture allowance. Therefore, the claimant has a bounden duty to prove his entitlement to the reliefs by adducing cogent credible evidence to prove his entitlement to the third claim. This burden can be discharged by the claimant if he is able to refer to the court to the law, conditions of service, agreement, or document that granted the entitlement. In his attempt to prove his entitlement to the reliefs sought before the court, the claimant relied on the provisions of Cross River State Political, Public, and Judicial Office Holders Remuneration Package Law Number 12 of 2007, hereinafter refers to as the Law Number 12. The use of the word may in the letter of appointment did not exempt him from taking the benefit contained in the law. To further support his claim, the claimant relied on the provisions of Section 5 of the Revenue Administration Law that provide for the claimant and the board members to be paid emolument and allowances as is applicable in the public service of the state. And as public servant, he is entitled to benefit. The defendant in denial of the claim stated that the sum of 21 million, the sum of 3,600,000 being per annum provided for in the letter of employment was claimant's consolidated salary and not his basic annual salary as alleged in paragraph 7 and 11 of the statement of fact. The claimant's salary and other financial entitlement as captured in the letter of appointment and accepted by him upon assumption of office were not based on law number 12. It is also the case of the defendant that the claimant's letter of appointment was explicit that further financial entitlement may be determined by the governor, and this is a discretionary. This is discretionary and not mandatory. The defendant denied claim that the claimant's entitlement was withheld by the defendant. Now, the question that need to be resolved is, has the claimant, by the evidence adduced before the court, been able to prove entitlement to any of the reliefs? The counsel for the defendant has submitted that the claimant's letter of appointment is clear regarding the claimant's remuneration, emolument, and other financial obligations. Counsel also submitted that the Revenue Mobilization Law, Exhibit CWG, on the other hand, is also very clear. It limits the terms and conditions of claimant's appointment to the specification of the letter of appointment as stated in Section 4, subsection 2, 42V thereof, which state that the chairman and members of the board other than ex-officio members shall hold office on such terms and conditions as may be specified in the letter of appointment. Counsel argued that it is clear from the letter of appointment and provisions of Section 42 subsection B of the Revenue Administration Law that jointly form the terms and conditions of the claimant's appointment. This leaves room for no misinterpretation or misconception whatsoever by making clear what the claimant's entitlement was, tying same to the stipulation in his letter of appointment, and emphasizing that any further financial entitlement were purely discretionary by the deliberate and intentional use of the word may. The defendant is therefore not indebted to the claimant, having bound himself to the terms and conditions of the claimant's appointment by paying his salaries and all other benefits enjoyed by the claimant during the pendency of the claimant's robust appointment as claimant as chairman, Cross River State Board of Internal Revenue. The claimant believes that he is entitled to severance pay and furniture allowance and hinges this claim on the Cross River State Law number 12 of 2007, which is Exhibit CWN before the court, and Section 5 of the Revenue Administration Law as contained in Exhibit CWG. It is submitted that the claimant is not entitled to the benefits of the public officers remuneration package law, Exhibit CW1, as the specific beneficiaries of that law were mentioned, but the office of chairman was given a very restrictive and specific definition, which eloquently excluded the claimant's office as chairman of Board of Internal Revenue. The law contemplated three categories of beneficiaries selected from the executive, legislative, and judicial arms of the state, arms of state and local government. See Schedule 1 to the said law. It is argued that in the said Schedule 1 under executive category, specifically term in 3, the word chairman is asterisk. In the area marked note, also asterisk, chairman is specifically defined as chairman of State Civil Service Commission, State Judicial Service Commission, State Independent Electoral Commission, Local Government Service Commission, and such other commissions as may be established by the Act of National Assembly, Chief of Staff to the Governor. Council emphasized that the phrase and such other commission used in the law is generic, other than the Local Government Service Commission, which is the local government's version of the State Civil Service Commission, first mentioned. The rest of the named commissions have constitutional flavor, having all been established under Section 197 ABC of the 1999 Constitution as altered. This simply clarifies the nature of commissions contemplated by the press and such other commissions, and effectively excludes the Board of Internal Revenue or any other board at all. It is submitted that a justum generis rules of interpretation may be called in aid, and the rule is to the effect that when specific words are used in statute, the general words follow. The general words are not to be read at large, but in line with the specific words. For the claimant, the law setting up the establishment where the claimant worked, Exhibit CWG, the Cross River State Revenue Administration Law state very clearly in Part 1 of Section 5 that the emolument that the claimant, the chairman, and board members shall be paid such emolument allowances, benefit as is applicable in the public service of the state, according to council, as at the time claimant's appointment and at the time of the claimant's appointment until this moment, there is only one law in operation that govern emolument allowances and benefit of public officers, public office holders in the state, and that is the Cross River State Public Office Holders Remuneration Package Law, CWN. The defendant's argument to be sustained for the defendant argument to be sustained that the claimant is not listed in the beneficiary as of an existing law, there should be a law or a document to that effect. This has to be proved by defendant, as the defendant owed this court an obligation to abar to the contrary that notwithstanding the provisions of in Exhibit CWG and CWN, a further document that is not before this court exists to exempt the claimant from being a beneficiary of the Cross River State Remuneration Law for Political Public Judicial Office Holders, number 12 of 2007. And since such document is not before the court, counsel invites the court to rely on the literal rule of interpretation in which the court are enjoined as ascertain the meaning of the word used by reading them in their ordinary grammatical sense and to give effect to them unless such construction would lead to some absurdity or would be repugnant to the intention of the intention to be collected from parts of the statute. According to counsel, reference is made to Schedule 1A, Chairman of State Civil Service Commission, State Judicial Service Commission, State Independent Electoral Commission, and such other commissions. Council submitted that such other commissions will accommodate the positions of the claimant in this case. Council also refers to the definition of the word commission as obtained in the Black's Law Dictionary. Council also submitted that the question that arises from this definition is whether the Board of Internal Revenue Service is a body of persons acting under lawful authority and performing a public service. Council answered in the affirmative because the powers and the function of the board are contained in sections 6 and 7 of Exhibit C WG. It is therefore, according to council, it is therefore a commission, notwithstanding the absence of the word commission in its name, because it is established by Act of State Assembly as captured in Exhibit CWN. For council, this also account for why the law establishing the Internal Revenue Service says that claimant, chairman, and its members shall be paid emolument allowances benefit as applicable in the public service of the state. Council submitted that it is an accepted principle of interpretation of statute that a court can supply an omission in a law to ensure reasonableness. Council further argued that the claimant and the board members of the Internal Revenue are captured by Cross River State Remuneration Law in view of the definition of public service of a state as contained in Section 318, subsection 1 of the Constitution, where a public service was where public service of a state means the service of the state in any capacity in respect of government of the state and include service as member or staff of any commission or authority established for the state by this constitution or by law of a house of assembly. Council asked the court to hold that the Internal Revenue Service being the established law of the House of Assembly, the claimant under which the claimant serves, the claimant is a public service within the Cross River State because according to council, it is an authority or commission provided for within the Cross River State Remuneration Package Law as shown in the law. Exhibit CWF. According to council, severance grant is only due to every applicant at the end of his service. It is not a discretionary grant that is an applicant is not a discretionary grant that His Excellency the Governor can deny it or withheld from an applicant, except the applicant is not an appointee of the dependent within the remuneration package. It is submitted that The purpose of these provisions is that the letter of appointment must be pursuant and subject to the law establishing the revenue service and not otherwise. In other words, the law establishing the board regulates their letters of appointment, and the content of their letter must conform to XBCWG. And with respect, that is our jurisprudence, as the law is the foundation of every action, and inaction anything to the contrary is ultra bias law, is ultra bias, the law. Claimants appointment, screening, etc. were based on the law establishing the internal revenue service, and letter of appointment was not was not was and must be issued pursuant to the said law. Any content in his letter of appointment that is not intended with the law setting up the place obviously will be a nullity, irrespective of who signed the letter of appointment. He refers to the case of Jegede and another by Anek and others. He also referred to Akande versus Jegede. It is submitted that the claimant is entitled to emolument and benefit as contained in Cross River State Remuneration Law for Political Public Office Holders number 12. Council asked the court to rely on the provisions contained in Exhibit CWG and to hold that only remuneration existing for public office holders is the one before the Honorable Court, as the defendant have not presented any law exempting the claimant from being beneficiary of the law. It is submitted that the claimant has proved his case based on the documentary facts before the court. The defense of the defendants to the claim is narrowed to the fact that XBCWN did not expressly mention claimant as beneficiary, and the first paragraphs of the claimant letter of appointment is restrictive. From the pleadings and evidence of the parties, it is clear to me that the controversy to be resolved in this case revolves around proper interpretation of the provisions of the law number 12, Revenue Administration Law, and the claimant's letter of appointment XBCWF. For the claimant to succeed in an action claiming payment of severance benefit or grant and the furniture allowances under the Political Public Judicial Office Holder Law will depend on several legal considerations. To start with, the nature or status of claimant's employment must be determined, as the letter of appointment clearly stated that the appointment is at the pleasure of the governor. Firstly, the nature of the appointment. On the nature of the appointment, the letter of appointment XBCWF has clearly stated that the claimant's appointment is at the pleasure of the governor. This implies that the appointment was a discretionary one, and such appointment does not normally guarantee tenure or benefit beyond the period of service, unless explicitly provided by law or contract. See the case of Governor of Ekiti State versus Oni and others. It is right law that the power to make employment with the operation of the Constitution and democracy in Nigeria, the power to make appointment at pleasure must be statutorily allowed or constitutionally provided for. In the case at hand, the law establishes revenue the revenue administration law did not provide for making of appointment at pleasure of the governor. The only instances where the governor can make appointment at his pleasure are as contained in the Constitution, which is a respect of the appointment of the secretary to the government, head of civil service, permanent secretaries, and commissioners. These are the constitutionally recognized area where a governor can make an appointment at pleasure. Therefore, the purported letter of employment stating that the employment of the claimant is at pleasure cannot stand in the face of the clear and unambiguous provisions of the law, as there was no such power to make such appointment. However, by Section 3A of the Cross River State Administration Law as amended, the chairman of the chairman of the Cross River State Revenue Service is to be appointed by the governor, subject to confirmation of the State House of Assembly. The claimant in this case was by the exhibit CWE appointed as chairman of Internal Revenue Service by the governor This means the appointment was for a period of 4 years as stipulated, was appointed by the governor from 18th of June 2019 to be valid until 26 June 2023. This means that the appointment was for a period of 4 years as stipulated in Section 4 subsection 2A of the Cross River State Revenue Administration Law. By the provisions of Section 4.2b, the appointment shall be on such terms and conditions as may be specified in the letter of appointment pursuant to provisions of the law. By Section 5 of the Revenue Administration Law, and the chairman and members shall be paid such emolument and allowances and benefit as is applicable in the public service of the state. The claimant has argued that having been appointed by the governor and the appointment having been confirmed by the State House of Assembly as per XBCWH, and his appointment having been made pursuant to the provisions of Cross River State Revenue Administration Law, he is in the public service of the state. According to the claimant, by Section 5, his emolument, allowances, and benefits shall be as applicable to public service of the state. And since there is no any other law prescribing emolument allowances for public service for public officers, apart from law number 12, he is entitled to benefit from the law. I have no doubt in my mind that an appraisal of the provisions of Section 3A, 42B, vis-a-vis Exhibit CWH will clearly show that notwithstanding the content of Exhibit CWE that stated claimant's employment to be at pleasure of the governor, the said appointment was not at the pleasure of the governor, as the said appointment was statutorily made under the revenue law and was not a discretionary appointment made at the pleasure of the governor. It was a statutory appointment made pursuant to revenue administration law. Therefore, the claimant, though not being an employee in the civil service, is nevertheless an appointee in the public service of the state. See Section 318 of the Constitution of the Federal Republic of Nigeria. Now, the question that called for resolution is whether the claimant, having been in the public service, is entitled to benefit from the provisions of the law number 12. For the defendant, the claimant is not entitled to take benefit under the law as number 12, while the claimant is insisting that he is entitled to benefit since there is no other law that prescribes benefit of officers in the public service. The claimant further argues that notwithstanding lack of his office being mentioned in the law, the court has power to fill in the gap, taking into consideration definition of commission as contained in Black's Law Dictionary. The court, in exercising power of interpreting provisions of statute, is guided by principles laid down by precedent. The general rule for construction of a statute is that where the words of a statute are clear and unambiguous, the court shall give effect to those to the words in the statute to give them their literal meaning. It is only when the literal meaning may result in ambiguity or injustice that the court may seek internal aid within the body of the statute itself, or external aid from a statute, which is impari materia, in order to resolve the ambiguity or avoid doing injustice. See the case of Mobil Oil Nigeria Limited versus Federal Inland Revenue Service. See also Olawoyin versus Attorney General of Northern Nigeria. See also the case of Obadara versus the President Ibadan West District Grade B Customary Court. See also the case of Nigerite Limited versus Delami Limited. Therefore, it is one of the cardinal rule of construction of written instrument that the words of the written instrument must in general be taken in their ordinary sense, notwithstanding the fact that any such construction may not appear to carry out the purpose which it might otherwise be supposed was intended by the lawmakers or maker of the instrument. The rule is that in construing all written instruments, the grammatical and ordinary sense of the words should be adhered to, unless that will lead to some absurdity or some repugnancy or inconsistency with the rest of the instrument. The instrument has to be construed according to its literal import, unless again there is something else in the context which shows that such course will tend to derogate from the exact meaning of the words. An express provision in an instrument exclude any stipulation which would otherwise be implied with regard to the same subject matter. Express the Latin maxim that clearly covers this is expressio facit casero tacitum. In the circumstances of this case, there is no room for the view in the face of the express language. Therefore, where the words are clear, where the word of a statute are clear and unambiguous, they must be given their ordinary meaning, unless this will lead to absurdity. In Obiawe versus Integrated Rubber Product Nigeria Limited, and another, the Supreme Court has this to say: the rule of construction of Acts of Parliament is that they should be construed according to the intent of the Parliament which passed the Act. If the words of the statute are in themselves precise and unambiguous, then no more can be necessary than to expound those words in the natural and ordinary sense. The words themselves alone do not in such a case best declare the intention of the lawgiver. If the words are plain and unambiguous, recourse to interpretation aid by use of preamble, titles, context, purpose will not be necessary. See the case of PDP and another versus INEC and others. The guiding rule of interpretation of statute or instrument are well settled by plethora of authorities. Therefore, in all interpretations, a plain word of statutes must be given their natural and literal meaning. It is only where ordinary literal meanings are ambiguous, word fails to bring out the intention of the lawmaker or lead to an absurdity that the result is to be made to other aids of construction. See Dixon versus Silva. See also registered trustees of Nigerian operation, trustees of airline operators of Nigeria and Nigerian Airspace Management Agency. See also Amechi versus INEC. Therefore, the provisions of statute must always be interpreted to achieve the obvious end for which the statute was enacted into law. See Assam versus Ararume, Farage Bibles, where an interpretation will result in breaching the object of the statute, the court will not lend its weight to such an interpretation. See Dixon versus Silva, Sufra. However, where there is gap, duplicity or ambiguity, or where the words of an enactment are capable of two meanings, a contextual rather than a literal approach should be prepared, as it is the duty of the court to give meaning that will resonate with sense, order, and the workable system. In so doing, the provisions of the statute must not be read in isolation, but the whole of the statute must be read. The true meaning, to ascertain the true meaning of the statute. See Buhari versus Obasanjo, see Fa Ayola JSC, see also Akpambo versus Okadibo versus Chidi, number 1. Fa MD Muhammad JSC as his was. It is equally vital to read all the integrated and interrelated statutory provisions under consideration together, not in isolation or by installment. CAG Benue State versus Umar. See also Dimegu versus Ogunwe. See also registered trustees, ETC versus Medical Health Workers Union of Nigeria, and Inajoku versus Adeleke. It is in line with the above well laid down principles of interpretation of statute that I shall consider the provisions of Cross River State Political, Public, and Judicial Office Holders Remuneration Package Law 2007 and the Cross River State Revenue Administration Law with its amendment in order to ascertain whether the claimant is entitled to benefit from law number 12 of 2007. It is by so doing that this court will be able to reach a just decision on the dispute submitted to it for resolution. A critical holistic examination of the Cross River State political, public, and office holders remuneration package law 2007 will show that the law was enacted by the Cross River State House Assembly to specifically make provisions for payment of salaries, allowances, and fringe benefits. Benefit was effect from 1st of February 2007 as prescribed in the schedules to the law for benefit of persons stated therein. See Section 1 and Section 2 of the law. It is clear by Schedule 1A, this law did not make provision for payment of annual basic salary. This law has made provisions for payment of annual basic salaries to 5 categories of persons, namely governor, deputy governor, commissioner, secretary to the state government, head of civil service, and chief registrar, auditor general, state and local government, accountant general. It is pertinent to note that the chairman was defined to mean chairman, State Civil Service Commission, State Judicial Service Commission, State Independent Electoral Commission, Local Government Service Commission, and such other commissions as may be established by act of the State Assembly, Chief of Staff of the Governor. It is the defendant maintains that under chairman, it is important. It is only the chairman specifically mentioned in this definition that are entitled to take benefit under the law number 12 of 2007, while the claimant is of the view that the definition of claimant as contained in the schedule to the law should not be restrictive if it is confined, should not be confined to the categories, and if it is restricted or confined to the categories stated in the definition, it would deprive the claimant of his right to be paid emolument and other benefit as is applicable to public service in the public service as provided for by Section 5 of the Revenue Administration Law. On this, I am at ad idem with the submissions of learned counsel for the defendant on the definition of chairman. On the submission that the chairman contained in the law shall be the chairman contained in the law shall be the only chairman to be entitled or to take benefit from the law number 12 of 2012 as the chairman Internal Revenue Service cannot be accommodated as there is no provision for such office in the said law. The reason being that the law where a statute has defined a words or terms, the court is bound by the definition as the court is not allowed to resort to any aid, either internal or external, to accommodate persons that are not specifically defined, that are not specifically meant to benefit. As in the statutory interpretation, when a word or terms has been defined within a statute, the definition provided by the statute is generally binding and should be used in interpreting the statute. This principle is rooted in the need for consistency and clarity in legal interpretation, ensuring that the legislative intent is respected and applied uniformly. The principles guiding this approach on interpretation is well established in the case law. For instance, in the case of APC versus Aguma and others, the Court of Appeal emphasized the importance of adhering to the statutory definition provided within the legislation. Similarly, in Aguma versus APC, the Supreme Court reiterated that where a statute provides a definition for a term, that definition must be applied. A resort should not be made to external definitions unless the statute itself is ambiguous or silent on the matter. However, there are exceptions to this rule if the statutory definitions lead to absurdity or is ambiguous. Court may look beyond the statute to interpret the term. This is supported by the case of Dafia Long and others versus Darie and another, where the court held that external aid could be used to interpret a statute if the internal aids, such as definition within the definition, are insufficient. See All Progressive, see APC versus Aguma Sufra, where per IG JSC, I quote, the inviolate position of the rules of interpretation of a statute or the construction is that where words or word used in the statute or constitution have or has been defined or assigned within meaning for the said statute or constitution, the whole as the words as legally or judicially defined will prevail without any embellishment from the court called upon to interpret or enforce the provisions of the law or statute. See the case of Acme Builders versus Kaduna State Water Board and another. See also Honorable Justice Kalu, Anya, and others versus Dr. Pestis Iyai. It is well settled that where a word has been defined in a enactment, that meaning must be restricted to the words so defined in the statute. The definition governs. See Apampa versus State. See also Professor Jerry Gana, CON versus SDP and others. The cardinal principle of interpretation that when the words of Satu or instrument are clear and unambiguous, they must be given their ordinary, natural, simple meaning. A court of law in its interpretative jurisdiction lacks jurisdiction to import or input into the statutory provisions words which are not therein used. Its duty being only to interpret the provisions in order to bring out the meaning of the word used in the statute and the intent of the lawmakers. See the case of Unipetrol versus ESBR. See also Obueze versus Obueze. Thus, it is long settled that court shall not allow itself to be invited to debate from clear and unambiguous words that make up the statute. The court must give the words their natural meaning in order to avoid the suppression of the real meaning and intention of the lawmakers. See Aguma versus APC Sufra. In the case at hand, the statute under consideration, that is the law number 12 of 2007, is not ambiguous or silent on the matters to warrant resort to Black's Law Dictionary on the meaning of the word commission, so as to accommodate the claimant in this case. Another reason why the claimant in this case is not covered under the law number 12 is that the chairman mentioned are those of the Constitution, are those that the Constitution has vested power to state assemblies to specifically make law for their emolument and other fringe benefits. In the circumstances, the claimant's claim the claimant's submission that there is no other law that governs emolument and other benefits of public service is wrong and cannot be true. As the definition of public service as provided for in section 318 of the Constitution, which he also relied on, is very vast and wide. It covers civil servants, persons working in ministries and extra-ministerial department. It is not only those appointed to serve in the revenue. It is only not for those to serve in the revenue, to serve in the Internal Revenue Service. It is also to be noted that the claim of the claimant to the sum of 21 million naira is a special damages claim that requires strict proof with cogent and compelling evidence. The payslip tendered are not helpful to the proof of the claimant's claim in that the payslips only showed gross and net pay of the claimant. The claimant having failed to prove his basic salary, he cannot claim to be entitled to 21,600,000 naira unless he can strictly prove that his basic salary is 3.6 million naira as alleged. However, from the payslip, it is clear that the basic salary is not 3.6 million, and the claimant has not, since the claimant has failed to prove his basic salary, he cannot be accommodated. And even looking at the basic salaries that were provided in the law number 12 of 2007, there is nowhere you will find 3.6 million as one of the basic salaries for any of the persons stated to be entitled to basic salary per annum. The failure of relief A means failure of relief B and C, as these two reliefs are ancillary claims dependent on the grant of relief A, which is the main claim in this case. I note claimant has attempted to even argue that the letter of employment is ultra biased for non-compliance with revenue administration law. Unfortunately for the claimant, no relief has been raised challenging the validity of the state letter of appointment, as the main claim is severance grant and furniture allowance, and the court is duty bound to confine itself to consideration of the claim as presented by the claimant and not deviate from it to delve into determining whether the letter of appointment is ultra biased to the powers of the governor or not. And if that is to be the case, then the entire claim of the claimant also must collapse, as there is no basis for the claimant to have come to court, as he has not, if he cannot show that he is an appointee of the claimant. If the appointment letter is nullified, then it means the claimant too will lose all his entitlement. So by whatever angle the claim of the claimant is looked at, the claimant has woefully failed to prove entitlement to the sum of 21,600,000 naira at his furniture allowance and severance grant as provided under law number 12 of 2017. As earlier pointed out, the claimant was not mentioned in that law. He cannot take benefit. The mere fact that he is in the public service does not mean that he must take a benefit from the provisions of law number 12 of 2012, because there are other public servants that are also having the same status with the claimant that are not taking benefit of the law number 12 of 2012. So now, for the court to now include the claimant, it means that the court is changing the law to suit the claimant's desire. The court is not meant to do that. The court is meant to espouse the law and also to interpret the law to bring out the intention of the legislature. As the claimant said, history of legislation should also be considered. If that is the case, the law number 12 was made for those officers that the law has conferred power on the state assembly to make provisions for their emoluments and other fringe benefits, and not for all public servants or people or all personnel in the public service of the state. From all I have been saying above, the claimant has woefully failed to prove his case, and having failed to prove his case with cogent and compelling evidence, the case collapsed, and same is hereby dismissed. I make no order as to post parties to bear their respective court. Judgment is hereby entered accordingly.
As a
As the
conclusion.
court pleases.
My lord, we thank you for the judgment. Thank you for
You are
your
welcome.
industry. We are
You are
grateful.
welcome. You're welcome. Thank you, counsel. I think we have come to the end of today's virtual proceeding. The administrator, you can do away with the sitting. You can discontinue with the sitting. Thank
As
you,
the court
counsel. We
please.
have come to the end.
As the court
We have
pleases.
come to the end of the sitting.
As a
Yes.
court pleases.
My lord, we
Thank you,
thank
my
you for the judgment.
You are welcome.